Hola, muy buenas tardes. Yo soy el abogado James Betzold. Good afternoon. I am attorney James Betzold. I think this video we are going to actually go forward with in English. I'm an immigration attorney here in West Michigan. We serve clients in Michigan and throughout the United States and the world. So let's begin with a little bit of an update. We have some updates on the Family Unification Parole Program. As you may know, that Family Unification Parole Program is currently on pause. It'll be on pause until at least September 23rd. This is because of a federal court decision putting it on pause while the case against the Biden administration gets going. Now, we deal with this every day in our office, and some of the common questions we get are, well, the program's on pause. What can I possibly do now? Can I still file applications? And there's a lot of great answers to that. So right off the bat, let's get to it. First of all, let's make sure we've got our audio settings working here. Okay, and we've got a couple people watching. Great. So thank you for joining. I'm attorney James Betzold. I'm an immigration attorney here in Michigan and in the United States. And now we've got a few more people watching. Okay, great. So the update for today for you people online. The Biden Family Unification Parole Program is on pause, kind of. When I say kind of, we can still file applications and they will get accepted and they'll start getting processed. They're going to run the fingerprints of the person who needs the fingerprints, who's applying for the application. They're going to issue receipt notices and it'll be in process. And this is actually great news because sometimes when a program is paused, you can't file applications anymore. But with this particular program and in this court decision, they are actually still allowed to accept new applications and move those forward. The only thing they can't do is give a final approval on it. Now, as an attorney, we have an opportunity to review different types of cases that the government gets sued for. Sometimes we have to sue the government because they're moving too slowly and even in violation of law because they're going so slow. But with this particular application, we can still continue to file them. This means if you are someone who qualifies or potentially qualifies for this Family Unification Parole, once that pause ends, if you're already in the system, if you've already submitted that application and you're moving along, the moment that window opens, even if it's only open for an hour or a day or a couple days, or maybe it's only open for a week before it gets paused again, during that time period, USCIS can issue tons of approvals. If they so desired, right? That window's open, they can issue the approvals for the ones who've had their fingerprints taken, for the ones who already submitted their applications with sufficient evidence. So that's actually a really important thing to know, is that we can still submit these applications. Once that window on a pause opens up again, USCIS can give more approvals. Now, there's some people who filed super early, they were super prepared, and they have approvals already, right? So this is it is something that is going forward. Now, for those who are watching, thanks for tuning in. I know on a Tuesday afternoon you might have better things to do. There is definitely a presidential debate coming up, which I'm sure some people are going to be watching. But I'm here to take questions today as well. So if you have an immigration-related question, a legal question, please submit a comment either in the YouTube comments or in the Facebook comments. I will see those here. In fact, I'm watching it right now to see if any comments come in. Be happy to answer some questions. I encourage you to share this live stream with your friends. Just do me a favor, click share, share it, post it, and we're going to be able to get more people some help here. So one of the main updates today, again, is the fact that the Biden administration, the parole program that they created, it is on pause. But we can still file applications so that when it's unpaused, boom, they can issue a ton of approvals. So that's going to be very useful. It's going to be useful for everybody, anyone who can apply or qualify for this. Now, some people will ask, well, why is it such a big deal? The reason is normally a person, if they didn't enter the U.S. with a visa, if they don't have a family member in the military, if no one filed a petition for them before 2001, April 30th of 2001, then they have to go back to their home country, to the U.S. embassy there for their final visa interview. With the Biden parole program, this opens up a way for them to file efficiently, time-wise, money-wise, everything-wise, carbon footprint-wise. It's much more efficient for them to file their application and stay here. So their family can stay unified, stay united, stay physically in the same place while that process is going on. I'm attorney James Betzold. I'm an immigration attorney, 15 years of experience doing this. We're welcoming anyone who has any questions that they want to ask. You can do that by submitting a comment either in the YouTube or Facebook channels. So again, let's go over some of our updates for today. In fact, it may be worth our while here. I'm going to pull the laptop a little closer to me and open another window, and we can actually review the very latest on the Biden Family Unification Parole Program, which is still alive, though it be on pause for a brief moment. All right, now one of the things that's important to know as well is even if you don't qualify for the Biden Family Parole, or even if you don't want to go ahead and file an application with that right now for whatever reason, there are other avenues to getting your status here in the United States. So I met with someone recently, a DACA recipient, so someone who has DACA, and they were thinking this Biden parole program would be the only one that would help them or that they would be interested in, but actually we uncovered another avenue. So for someone who has DACA, and for those tuning in, thank you. Submit your comments, submit your questions. I'll be happy to answer them. I'm Attorney Betzold. I'm the immigration attorney here, and so we're happy to have you with us. But for individuals who have DACA and they want to obtain their status here in the United States, there is an option for them to apply for what is called advance parole. Advance parole is separate from the Biden Family Unification Parole. It's something that still exists. DACA recipients can apply for and get it for family purposes, for emergency purposes. If you need to visit a family member outside the United States, you can do that as well. But the idea is you get this permission to travel. You then travel outside of the United States, and then as you enter lawfully, now you're qualified to have your spouse file a petition for you and for you to get your papers here in the United States without having to leave or go through a lengthy separation of your family. So again, for those of you who are watching, I'm inviting your comments. Thank you for joining us. I'm an immigration attorney with 15 years of experience working here in the hardest of all cases that exist for immigration clients. We're talking, we've handled immigration court cases, asylum cases. I know that's still a big deal, asylum cases. Family petitions, we've handled certain employment petitions as well. Waivers, we've done a lot of waivers. We've helped a lot of people who have needed assistance because of a prior immigration violation or an immigration court issue or a prior removal order or other criminal issues that maybe could prevent somebody from obtaining their residency here in the United States. We specialize in all of those things, and we welcome your questions today. If you're watching, I'll just put up some information here about our firm. You can call us to schedule a consultation as well. Here's the website, visafeliz.com. I'm attorney James Betzold. Our phone number is 616-396-9418. And right now, let's actually present some information here about the Biden Family Unification Parole Program. We know that it's on pause, but it is also important to keep families united during this time, and so we are going to give some attention to this information right here. Now, here in the United States, when someone enters the United States lawfully, that gives them permission to file their paperwork in the United States when they're eligible based on a family petition, for example. So let's talk about what it takes to become eligible for the Biden Family Parole Program. So first of all, this is a program that's designed to help individuals who've lived in the United States for at least 10 years. And it's 10 years counting backwards from June 17th of 2024. Now, having lived here for 10 years is important, but also it's important that you're married to a U.S. citizen or was married to a U.S. citizen on June 17th of 2024. Okay, so we've got that requirement right here. Now, this is the tricky part. Have no disqualifying criminal history and not otherwise deemed to be a threat to public safety, national security, or border security. Okay, and of course, then they're going to want to take your fingerprints to check that. All right, so here we're going to focus mostly on the requirements for the spouse of a U.S. citizen. This is by far going to be one of the most common types of cases out there. Now, dealing with that, we have those requirements met. What's happening now? The whole program is on pause only for approvals. We can still submit applications. We can still move forward with applications. And there's quite a bit of documentation that's needed. So while this window of opportunity is open to submit applications, it's advisable to do so, because for a lot of people, it's the difference between being separated from your family for months at a time, possibly years, and being able to get your green card within about 18 months here in the United States. Welcome to everyone who is watching. I want to invite you to submit any questions you may have. I am an immigration attorney. I am licensed to practice in the state of Michigan, in the Eastern and Western Federal District Courts of the United States, some other federal district courts throughout the country, and all of the immigration courts in the United States as well. So I've got a breadth of knowledge on all of these topics. También hablo español. Si prefieres hablar o hacer sus preguntas en español, por favor, dame. You can submit a question by adding a comment either in Facebook or on YouTube. Wherever you're seeing this, add a comment. We will see it. We'll take all measures possible to answer your questions. So go ahead and share this stream. Share this with your friends and family. Put it on your feed. Let everybody know that this right now is live. I am a real person. I am a real immigration attorney. I am not an AI model, as the case may be, but we do have pretty good information for those who need it. So we're talking about other avenues to get your status in the United States when the Biden Family Parole Unification Program might not work for you. It doesn't work for everyone, but it does work for many people. And so again, it's important to know what all of your options are. When we do a consultation with a client, we have a pre-interview with our assistant. So for example, one of our assistants will call. They're going to gather some information because I want to be ready to spend as much good time with the client, getting to answers and results as possible. So let's talk about DACA. We mentioned earlier, individuals who have DACA, they can qualify for the Biden Family Reunification Parole Program, even though it's on pause. But there's something better they can do many times. With something called advanced parole, they can actually get advanced permission to leave the United States and then to return to the United States, and they're entering lawfully. And because they're entering lawfully, now they can do what's called adjustment of status. Adjustment of status is just the application we need to file in order to get somebody their green card. So as long as they're pre-qualified and we make sure that everything's in order there, that there's no prior removal orders, and that there's no other grounds of inadmissibility, it can be a pretty painless process. We request permission from immigration so that a client can travel overseas. And this could be to visit a grandparent that maybe they've never met in person or haven't seen in 20 years, and now the grandparent's getting old, and now time's going by. Maybe an uncle, maybe an aunt, maybe another extended family member, maybe there was a funeral, and they want to go pay their respects now. Or it could be because of a work or education-related reason as well. These are all legitimate reasons to apply for advanced parole. And that's great. Once you get advanced parole, you travel, you enter the United States. Now, someone who has DACA can get this fairly straightforward. And now they can file for adjustment of status based on a family petition. All right, let's move along to some other information. Let's assume somebody doesn't have DACA, and they haven't been in the United States for 10 years, there's still a number of options open to them in order to obtain status in the United States. So let's go ahead and create a little more space here. For example, there is what we call the typical process. Now, it's a little bit lengthy these days, but someone who's married to a U.S. citizen can have a family petition filed for them. And right now, those are taking about 14 months to be approved. We could talk about the length of the other steps. However, they're pretty dramatically long right now. And I feel like within 14 months, those are going to drop significantly. And I really hope that they do, because it's a bummer. But filing that family petition can be the first step to eating away at a lengthy waiting process. When we file that family petition, the person typically doesn't leave the United States. Typically, they will stay here and wait for the approval of that petition. Other than that, there's waivers. right? There's what we call a provisional waiver, which we can file once the family petition is approved. That provisional waiver will forgive somebody being here unlawfully. Now, there's a few things to be aware of. Someone just being in the United States unlawfully for more than 6 months means they have a 3-year punishment. If they're here between 6 months and a year or more without permission, well, that's a 10-year punishment. And both of these things, assuming there's one entry to the U.S., are forgivable. There's waivers for it. If we can show that a U.S. citizen spouse or parent or a resident spouse or parent is going to suffer some extreme hardship, we can obtain a waiver for the client and they can continue on the visa process. Now, where it starts to get tricky and where we see a lot of people get tripped up is when somebody's applying for a family petition, right? And now you'll get a notification in your email saying, hey, it's time to fill out the electronic form online. It's time to get ready for the National Visa Center, the NVC, and for going to the U.S. consulate. Now, that's great. However, some people will jump straight to that when they shouldn't. And they'll forget or will not know that they actually, before they do that, they need to file the provisional waiver or notify the National Visa Center that they're going to be filing a provisional waiver so the case doesn't get closed too quickly or too easily. If you leave that case open and you don't log in and you're not checking on it, you're not submitting things, immigration will close that case for you. Actually, I had a client I was meeting with today. They had not taken much action on their case in a couple of years. They got a notification at one point saying, hey, warning, this is going to be closed. And then another notification saying, hey, we actually closed it now. And then another notification saying the whole I-130 family petition is now revoked because you didn't do anything with it. You got to start over. That's kind of a bummer because it's going to take the family years and years to get to where they were in the process before. So definitely important to have knowledgeable help with these petitions. All right, let's move forward. Let's talk a little more now about options. Well, no, let's talk about a place that really gets a lot of people tricked up, that people can get really confused on pretty easily. And this is what we call the 10-year permanent bar. Okay, now, someone who is in the United States for more than a year without permission, and then they leave, and then they come back or try to come back without permission, they're going to have a different 10-year bar. Their 10-year bar is going to be what we call the permanent bar. And when you have that permanent bar, in order to get a visa after you have that, you first have to leave the United States, then you have to wait 10 years, and then you have to file a waiver, which if it's approved, you can again move forward with your status. But this is an area that gets a lot of immigrants, a lot of even attorneys can get tricked up on this because there's so many things that are called the 10-year bar. But this one that we're talking about is the 10-year permanent bar based on unlawful presence of more than 1 year. And that time period, they start counting from the 1st of April of 1997. So if after April 1st, 1997, you have periods of time which eventually get to a year, then the next time you leave and come back, you're going to have a 10-year permanent bar. We do not send clients overseas to go to the consulate when they're in this situation. We let them know, hey, you actually have the 10-year permanent bar. There's no point starting your case right now unless you're willing to leave the country for 10 years. Then, of course, we can handle the case. But we let all of our clients know right at the beginning whether that's going to be possible or not, and how long things could really take. Because we hear these horror stories of people who get sent to, for example, Ciudad Juarez or Ciudad de Guatemala, where the U.S. consulate, they'll hold their interview. And at the interview, the person's thinking, okay, it's going to be a couple of weeks and I'll be going back to the U.S. But then at the interview, they're told, no, you're inadmissible. You have the permanent bar. You've got to be outside of the U.S. for 10 years, and then you can come back and we'll try this again. And that's devastating for people, especially since crossing the border is fraught with such peril at this point anyway. So it's much more useful, much more palatable to tell and be honest to a client. Say, hey, you're facing these bars. I'm sorry, we can't help you right now. Let's move forward. We can talk about VAWA. VAWA is quite a powerful program. VAWA in English, it stands for Violence Against Women Act. So there was a law passed by Congress that says if there is a migrant, an immigrant, or someone in the US who's married to a US citizen or resident, and now they've become a victim of domestic violence or extreme cruelty, they will be able to apply for a visa without having to leave the country and without having to notify their spouse, the abuser. That's super helpful. That actually helps a lot of people obtain status here in the United States without having to leave, even if they've entered unlawfully. Now, it's not a program that will forgive all grounds of inadmissibility, but it forgives many, and the most common ones. So when we talk about a VAWA case, we're typically talking about a case involving something like domestic violence, something like extreme cruelty, and a situation where there's really an imbalance of bargaining power between a spouse or some other family member. There's actually, you can file a VAWA case if you're the parent and your US citizen son or daughter is subjecting you to extreme cruelty or to domestic violence. So there's all sorts of possibilities under the VAWA program as well. And what that lets you have pretty quickly is first a work permit. So the person can begin working, be more independent from the abuser to possibly get out of the situation or travel away or move away from the abuser. And the other thing it leads to is United States legal permanent residency. So you get a green card at the end of that process. 5 years after that, you're eligible for a green card to turn into US citizenship. So a VAWA case is actually something that's very useful and has helped many people obtain status lawfully here in the United States. Welcome to those who are watching. I am taking questions today. This is live. It's a true live. We are not broadcasting a pre-recording. If you have any questions, go ahead and put those in the comments section to this video on either Facebook or YouTube, and I will see those and get to those right away. We are talking about some important immigration updates. The Biden Family Unification Parole Program, the latest updates on that. And I see we have somebody else here. Again, go ahead and throw a comment in YouTube or Facebook, and we'll be happy to answer your questions. I am an immigration attorney licensed to practice in the state of Michigan and throughout the United States. I have 15 years of experience, so I do know what I'm talking about. And there's a lot of good information that we can share. Right now, for free of charge, you're getting a pretty good deal. We typically charge $100 for a consultation to get on the calendar. So any questions you want to throw up there, go ahead and do that right now. Please take the time to share this live stream with your friends and family as well. Okay. All right. Well, we can move on now and we can talk about something else. We can talk about asylum. So I did have a few people discussing with me today in the office the topic of asylum. There's some things you just got to know about asylum. You've got 1 year from the day you enter the United States. The general rule is you have 1 year to apply for asylum. If you don't apply for asylum within the first year, then you either need to show that there have been changed circumstances, which now make it impossible for you to go back to your home country. You know, the situation there has changed. Or you're going to be limited to filing what's called a withholding only petition or withholding of removal application. It's got a higher bar when it comes to the amount of difficulty and persecution you need to show. And so it would be preferable always to have the asylum application. The asylum application eventually leads to residency if you're successful. A withholding of removal application does not. It provides you essentially a temporary administrative stay of deportation. In an asylum case, you're looking to prove one of a few things. First, you need to show that you've been persecuted, and you need to show that there's a connection between that persecution and your race, religion, political opinion, nationality, or because you belong to a social group that is being persecuted in your home country. Sometimes that can be tricky, so it is important to have assistance with that and make sure that you can qualify for it and that it gets submitted correctly, because you need an application pending for 150 days, an asylum application, before you can apply for your work permit. Right now, work permit is going to be a huge deal for someone who has asylum. But again, to get that, your asylum application needs to be pending for 150 days first. All right, so if you have any questions to ask, please go ahead and throw those in the comments. We will be happy to get to those. And we'll be monitoring the post later as well, trying to engage with anyone who posts a comment here. I want to thank you for joining us today. we've been spending this roughly half an hour going over just some of the updates with immigration. I guess we could take the last, let's do 5 more minutes, let's say, and anyone with questions can go ahead and throw those in. We'll just sort of summarize what we've talked about. We talked about the Biden family reunification parole program. This is for stepchildren of United States citizens and also spouses of United States citizens who have been in the U.S. for 10 years. If you're a stepchild, requirements are different. You don't need to have been in the U.S. for 10 years just since June 17th of this year, 2024. And that program is currently on pause, sort of. They can't give a final approval to those petitions that are pending right now. However, they are processing them. They are sending out requests for evidence. They are sending out fingerprint notices and receipt notices. So they're working on them, but they're not giving final approvals until another window opens up where they're not paused anymore. And the idea is at that time, they should be able to release a lot of approvals all at once. So stay tuned for more information on that. It looks like the scheduled date for that pause to come undone is the 23rd of September. If I'm not mistaken, I believe that's the date that we saw was September 23rd. Let's take a look here. And if we actually go back one more, I can tell you again. It was there for 14 days, KFT, yeah. We're going to learn more. Yeah, so it still is on pause, and it looks like September 23rd, again, is the date we're looking at for that. Well, if it's a 14-day pause, September 23rd, yeah, well, okay, well, it stays in effect through September 23rd. That's the official notice from USCIS right now. So, yeah, through the 23rd. I know I said a 14-day pause as of August 26th, and if you do the numbers, it would have been September 14th or less. But it is September 23rd is when that stays in effect. There are other ways to get your status, though. The Biden Family Reunification Parole Program is not the only parole program out there. There's military member parole. So if you have a member of your family, this could be a parent, could be a spouse or sibling, or a child, an immediate member of your family who is part of the United States Armed Forces or Uniformed Forces. So this includes the Army, Navy, Air Force, Marines, United States Coast Guard. One of those, if they're in the military, you can actually, as an immigrant, request parole. So you get a legal entry. That program is not on pause. That program still exists. We file those all the time for clients. Another type of parole, used less often, but we have had much success with those as well, is humanitarian parole. Humanitarian parole is essentially where you have a family member or some situation where, for humanitarian sake, USCIS should grant you lawful entry to the United States. Typically, this takes the form of a child who is sick, a spouse who is sick, probably with cancer, cerebral palsy, could be Down syndrome, could be severe autism. It could be something pretty severe where leaving them, not accompanying them, could take a serious toll on the U.S. citizen as well. So humanitarian parole is not on pause. Humanitarian parole is a living humanitarian parole program. We file those frequently as well, where because of some grave situation, USCIS can decide in their discretion to give you a lawful entry to the United States, and you can pursue a work permit and you can pursue a green card application in some circumstances. Again, if you have any comments about those things, go ahead and put those in the comments. We're going to take up a couple more minutes here. Just discussing different parole programs that exist. And of course, like we talked about with DACA, advanced parole still exists for DACA recipients as well. So if you're a DACA holder and you have a family member or some legitimate reason to travel, we're talking a family reason, family illness, grandparents are getting old and you want to see them before they might pass away. Maybe somebody's in the hospital, maybe something came up like that, family reason. Another reason can be because of employment. If you can get an employer that has some sort of training or some trip that requires you to travel outside the U.S., that's a legitimate reason for a DACA recipient. Also, education. Education is another reason that USCIS can grant a DACA recipient what's called advanced parole. In advance, they're giving you the permission to re-enter the United States in the status that you had before. And what's great about that is once you enter lawfully, you're eligible for other ways to get your green card in the U.S. So keep those all in mind. Biden family parole is somewhat on pause for now. It's gonna unpause at some point. But these other parole programs still exist and we can use them. Even besides that, there's the typical process, filing a family petition and obtaining the necessary waivers. We know how to do that here in Betzel Law, here at Visa Feliz. So I want to thank you for joining us today. Again, if you have any questions, go ahead and pop those into the comments. We will be monitoring this post so we can answer any questions you may have. Thank you and have a great evening.